Welcome back to the Deep Dive. Today we're tackling some really foundational legal ideas, stuff you absolutely need to get your head around for financial planning.
That's right. We're looking at legal identity, who can actually make a contract or, well, get sued, and also how you can legally give someone else the power to act for you.
Yeah, delegation through powers of attorney. We've got a bunch of source material here, and we're going to, really dig into it.
And the so what for you listening is massive. I mean, understanding this stuff determines who's liable if things go wrong, who owns what, and who's in control, especially, during big life changes like illness or even growing a business.
Okay, so that's the mission. Unpack legal identity and delegation. But here's the question for you right now. Are you sure your business setup actually shields your personal assets? Or, thinking about delegation, will that power you gave someone actually hold up if you couldn't make decisions yourself later on?
Big questions. Let's dive in.
Right, let's start at the beginning. This term, legal person or legal entity. What are we actually talking about here?
Well, it's basically anyone or anything that the law recognizes as having its own separate existence. So it can hold property, it can sign contracts, and crucially, it can sue or be sued in its own name.
And that's not just people, right? Like flesh and blood individuals.
No, definitely not. Obviously, natural persons, you and me, are legal persons. But the law also extends the status to things like companies, certain types of partnerships like LLPs, even things like trustees acting for a trust.
Okay, but you mentioned the critical thing earlier, liability.
Yeah,
That seems to be the biggest difference for most people listening.
absolutely. It all boils down to personal risk. Is the entity legally separate from you, the owner or founder? Let's take the sole trader first.
Okay, the sole trader, what's the deal there?
Simple, but risky. With a sole trader, there is no legal separation. The owner is the business. They are one and the same in the eyes of the law.
Which means,
It means if the business racks up debts, borrows money it can't repay, or faces a lawsuit, the owner's personal assets are completely fair game. Your house, your car, your savings, it's all potentially on the line. There's no protective wall.
wow, okay, that's stark. What about traditional partnerships? Are they any different?
Structurally, a bit, but in terms of liability risk, not really, not in the traditional setup. A traditional partnership is also not typically treated as a separate legal entity from the partners themselves.
So partners own the assets together.
Yes, but they're also jointly and severally liable for all the partnership's debts and obligations.
Okay, jointly and severally. Let's unpack that because it sounds, well, scary.
It can be. Jointly means all partners are liable together. Severally means each partner can individually be held responsible for the entire debt, regardless of their stake in the partnership.
So wait, if I have, say, a 10% share in a partnership, and my partners mess up and can't pay a huge debt,
The creditor could legally choose to come after you for the full 100% of the debt. They don't have to chase the others if it's easier to get the money from you. Your personal assets are still exposed.
that sounds like a massive risk. Why would anyone choose that structure then?
Historically, simplicity, maybe lower setup costs. But the trade-off on liability is huge. And there's another layer. Partners act as agents for each other. So one partner's actions in the normal course of business can legally bind all the others.
Right, so one person makes a bad deal, everyone's on the hook.
Exactly. It highlights why understanding that legal separation is so vital. Which brings us to the structures that do offer that separation.
Like companies, limited companies, PLCs.
Precisely. Companies, whether private limited, Ltd, or public limited, PLC, are the classic example of a separate legal entity. Once registered with Companies House, the company exists independently of its owners, the shareholders.
And that's where the limited liability comes in.
Yes. The company itself owns the assets and owes the debts. Shareholders' liability is limited usually to the amount they've invested or agreed to invest in their shares. If the company goes bust, the creditors can generally only claim the company's assets.
Not the shareholders' personal homes or savings.
Correct. Their personal wealth is protected by that legal separation, that corporate veil.
Yeah.
These companies operate based on their founding documents, the memorandum and articles of association. That's like their internal rule book.
Okay, so we have sole traders partnerships with high personal risk and companies with strong protection. Is there anything in between?
Yeah.
The sources mentioned LLPs.
Ah, yes, the limited liability partnership, or LLP. This is a really important hybrid structure, especially popular with professional firms like accountants or lawyers.
How does it work?
Well, the key thing is the LLP is a separate legal entity registered at Companies House, just like a company. This means the partners in the LLP generally have limited liability.
So their personal assets are protected.
Largely, yes. Their liability is usually limited to the capital they've put into the LLP, and maybe any personal guarantees they've given, perhaps for a bank loan. But unlike a company, LLPs are often taxed like traditional partnerships, with profits flowing through to the partners. So it combines that separate legal status and liability protection with partnership-style tax treatment.
Interesting. A sort of best of both worlds in some ways.
For certain situations, yes. It offers that crucial protection that traditional partnerships lack.
And quickly, before we move to delegation, the sources also mention other legal persons who act for others, trustees and personal representatives.
Right. These aren't business structures in the same way, but they are distinct legal roles. Trustees are appointed under a trust deed by a settlor. They hold and manage assets for the benefit of beneficiaries. They act legally in their capacity as trustee.
And personal representatives, that's about dealing with someone's estate after they die, right?
Exactly. This covers executors and administrators. The difference really hinges on whether there's a valid will. If there is a valid will naming someone to handle the estate, that person is the executor. They need to apply for a grant of probate to get the legal authority to act.
And if there's no will or no valid executor,
Then the person died intestate. In that case, usually a close relative applies to the court for letters of administration to become the administrator. Both roles involve gathering assets, paying debts, and distributing what's left. But the administrator follows strict legal rules of intestacy rather than the deceased's wishes in a will.
and the sources stress this isn't a small job.
Oh, definitely not. It can be incredibly time-consuming, complex, and carries significant legal responsibility. Onerous, as the material puts it.
Okay, so we've looked at the legal structures of businesses and representation. Now let's shift focus to delegating your own decision-making power, particularly for finances. This is where powers of attorney come in.
That's right. A power of attorney, or POA, is a legal document where one person, the donor, gives another person, the donee or attorney, the authority to act on their behalf.
Are there rules about who can be a donor or attorney?
Yes, both must be over 18 and have mental capacity when the POA is made. And importantly, the attorney cannot be bankrupt if they're being appointed to handle financial matters.
Makes sense. Let's start with the ordinary power of attorney. What's its main purpose?
Think of it as a tool for convenience, usually temporary. It has to be signed as a formal deed. It allows the attorney to manage the donor's property and financial affairs while the donor still has mental capacity.
So what sort of things can the attorney do?
Typical financial tasks, signing documents, operating bank accounts, buying or selling investments or property, making payments. They can also make gifts or purchases, but there are strict limits.
Limits, like what?
Well, everything the attorney does must be in the donor's best interests. They absolutely cannot use the power for their own benefit. And any gifts or spending must be reasonable, considering the donor's financial situation and their usual pattern of giving. You know, customary gifts for birthdays or charities might be okay, but not large, unusual amounts.
So why would someone set one up?
It's often useful if the donor is going to be abroad for an extended period, or maybe they're physically unwell and find it difficult to get out to the bank, but they're still mentally sharp.
Okay. Seems straightforward enough for temporary situations. But the source material highlighted a really big catch.
A massive one. The Achilles heel of the ordinary POA is that it automatically, instantly stops being valid the moment the donor loses mental capacity.
So the exact point where they might need the most help managing their affairs.
The power vanishes. Poof!
Okay.
It also ends automatically if the donor dies or becomes bankrupt themselves or if any pre-agreed time limit expires. This inherent flaw caused huge problems.
Right. That failure of the ordinary POA stopping just when it's needed most, that must have led to changes in the law.
It did. It led first to the creation of the Enduring Power of Attorney, or EPA.
Enduring power of attorney. Okay, how did that work?
EPAs were designed specifically to solve that problem. If an EPA was made correctly while the donor had capacity, the attorney could continue to act even after the donor lost capacity. However, there was a crucial step.
Which was?
Once the attorney believed the donor was losing or had lost mental capacity, they had a duty to register the EPA with the Office of the Public Guardian, the OPG. Only then could they continue using it for financial matters.
So EPAs are still around.
Well, you can't make a new EPA anymore. They were replaced in England and Wales from October 1st, 2007. But, and this is important, any valid EPA created before that date is still perfectly usable today. If the donor loses capacity, the attorney just needs to register the existing EPA with the OPG.
Okay, so EPAs were the bridge. What's the current standard then? The replacement?
That's the lasting power of attorney, or LPA, introduced by the Mental Capacity Act 2005. If you're planning for potential future incapacity now, the LPA is the document you need.
And how does the LPA differ? Is it automatically valid if capacity is lost?
Not quite automatically. The absolutely key point about an LPA is that it only becomes legally effective once it has been registered with the Office of the Public Guardian, the OPG. You can and should register it while the donor still has full capacity.
Register it before it's needed.
Ideally, yes, because the registration process takes time, weeks, or even months. Registering it early means it's ready to be used immediately if and when capacity is lost, or even before, if the donor wishes. And crucially, there are two distinct types of LPA you need to know about.
Two types. Okay, what are they?
First, there's the Property and Financial Affairs LPA. As the name suggests, this covers decisions about money and property, paying bills, collecting benefits, selling a house, managing investments.
And can the attorney use this one while the donor still has capacity?
Yes, if the donor chooses. When setting up the LPA, the donor can specify whether the attorney can act immediately upon registration or only once the donor has lost mental capacity. Most people allow immediate use for convenience, trusting their chosen attorney.
Okay, that's finances covered. What's the second type?
The second type is the Health and Welfare LPA. This is completely different. It covers decisions about your personal life, things like where you live, your day-to-day care, consenting to or refusing medical treatment. It's about quality of life, not money.
And when can the attorney make decisions under this one?
This is a critical distinction. Unlike the financial LPA, the attorney for health and welfare can only make decisions once the donor has lost the mental capacity to make that specific decision for themselves. They cannot use this power while the donor still has capacity.
So two separate documents covering two very different areas of life with different rules on when they can be used.
Exactly. And you really need both for comprehensive planning. One manages your assets, the other protects your personal well-being and wishes.
It feels like there are more safeguards built into the LPA system compared to the old EPAs. The sources mentioned notifying people.
Yes, that's a key protection. When making the LPA, the donor can choose to name specific people, up to 5, who must be formally notified when the application to register the LPA is sent to the OPG.
Why notify them?
It gives them a chance to raise concerns. If one of these people to be notified has genuine reasons to object, perhaps they believe the donor was pressured or the attorney isn't suitable, they have a formal right to object to the registration. It acts as a check against potential abuse.
Right, adding a layer of scrutiny. And who oversees all this? You mentioned the OPG.
Correct. There are two main bodies involved. The Office of the Public Guardian, the OPG, is responsible for registering both LPAs and the older EPAs. They also supervise attorneys acting under registered powers and deputies appointed by the court.
And the other body?
That's the Court of Protection. It's a specialist court that makes significant decisions about mental capacity itself, whether someone actually lacks capacity. It also resolves disputes about LPAs or EPAs, and it has the power to appoint a deputy to make decisions for someone who lacks capacity but never made an LPA or APA. Hashtag tag outro.
Okay, we have covered a lot of ground today. From the very definition of who you are legally in a business context, right through to who can step into your shoes if you can't act for yourself.
Yeah, I think the two absolute crunch points we've pulled out are, first, that stark difference in personal liability. The exposure you face as a sole trader or traditional partner versus the shield you get with a limited company or an LLP. Understanding that is fundamental.
Absolutely. And second, the evolution of delegating power. Realizing that an ordinary power of attorney just doesn't cut it for planning for incapacity, and why the lasting power of attorney, both types, property and affairs, and health and welfare, is really the essential tool for future-proofing your decisions.
Getting those LPAs set up and crucially registered with the OPG before they might be needed is so important for peace of mind.
We also touched on the significant responsibilities placed on people like executors, trustees, and attorneys. The source material didn't mince words, calling the duties, especially for personal representatives, time-consuming and onerous.
They really can be. It's not a role to accept lightly. Which leads us to a final thought for you to consider. Imagine you are asked to be an executor for a complex estate, or an attorney under an LPA, perhaps dealing with difficult financial or welfare decisions. Knowing what we've discussed today, the potential liability, the legal duties, the sheer amount of work involved, What practical steps would you take right now to make sure you could fulfill that role properly, protecting the interests of the person you're acting for, while also safeguarding yourself from legal or financial risk?
That's a heavy question, focusing on the responsibility you take on. Definitely something to think about.
Indeed.
Well, that's all we have time for in this deep dive. We really hope unpacking these legal structures helps you navigate your own financial world with a bit more clarity and confidence. Join us next time.